Welcome, everybody, to another episode of Tax Sale Insiders. I'm your host today. I'm Brian Seidensticker. I'm CEO of Tax Sale Resources. With us today, a returning guest is Will Hereford. He's a partner at Burr Forman, and Will has, experience in several states: Florida, Mississippi, Georgia, Tennessee. I think probably some others. Will, but you focus in your practice as an attorney is focused in Alabama. So we're gonna talk about some changes in Alabama. But anyway, welcome, Will. Thanks for hopping on.
Thank you, Brian. Good to see you. Good to talk to you.
Now, probably, for those that are listening, there is a more in-depth interview of I'll say the previous system in Alabama, which is, I guess you'll dig into the details of some of that surviving, right? So if you want a more detailed version, maybe go listen to that of what it was, right? But to kind of help set the table a little bit, Will, can you kind of give us a rundown or a summary of what that, I'd say there were multiple systems, what those systems were, let's say as of January of this year?
Yes. Thanks, Brian. I'm in Birmingham, and my practice is primarily focused on Alabama tax sales. I have other areas of practice, but I've spent a significant time since like the year 2000 with Alabama tax sales. And there have been some significant legislative changes this year in Alabama, the 2024 legislative changes. And before getting into those, though, I think it's helpful to understand that there are now two systems in Alabama for real property tax collection. There's the longstanding system that I refer to as the sale of land system. And then in 2018, legislation was enacted that it really enhanced an existing system that had never been used before, but I'll just say it created a new system, which is more like a lien sale system, where it's a lien bid down. And I'll go into that a little bit more detail. But the sale of the land system, the historic system used in Alabama, involves public auction of the property each year in the spring of properties with delinquent property taxes. And the winning bidder is the one who bids the most for the property. And that often results in bids that exceed the amount of taxes. And when that happens, you have an overbid that the county holds until the property is redeemed, until that overbid is otherwise claimed. That's the historic system. And in that system, the buyer gets a certificate of purchase, which 3 years later can be converted to a deed representing actual title in the property, subject to continuing redemption rights. The new system, it's an annual sale as well, same time of year, the spring, generally March to early June. And in that system, the bidders are bidding down the interest that will be paid on redeeming the property. So if there's a property that has $1,000 in taxes owed, the bidders are bidding down the interest they would receive from the owner when the property is redeemed. And that bidding starts at 12%, and it can bid down to zero. And if it gets down to zero, there's some sort of kind of, not a lottery, but some system to just randomly select which bidder gets the property. So in that system, the winning bidder pays the amount of the taxes, and then the former owner has certain redemption rights that we can get into in more detail that last. And then when they redeem it, they would be paying back the taxes plus the interest to the bid down level. So if it's bid down to zero, the redemption is only going to be the amount of the taxes that were being paid to the purchaser. Those are the two systems that exist out there. And majority of counties in Alabama have adopted that latter system, that bid down system, lien bid down system. There's still a number of counties in Alabama that use the old system, the land purchase or land sale system. So the changes affect those two systems. The first one that I'm going to talk about is Act 2024. Section 80 or -83. And that one relates specifically to the sale of land system. So under the sale of land system, as I mentioned earlier, the properties are listed and auctioned off to the highest bidder. And if there's not a bid made that's sufficient to pay off the taxes that are owed, the property is deemed to be sold to the state of Alabama and actually goes on a list of properties that the state owns. And then the properties can be redeemed from the state. But that number of properties sold to the state just has increased year after year after year, to the point where I think at one time there are like over 30,000 properties that the state was holding from those sale of land sales. Well, the system used by the state, the Alabama Department of Revenue, all right, so the state owns those properties technically, and those properties can be reduced or taken away from the state by one of two ways. One would be an owner going to the state and redeeming the property, which is not a very complicated thing. The other would be that there would be investors who go to the state and want to buy those properties. And actually, there's a third method too. There's creation of some land banks in Alabama, and those land banks have gone and acquired some of those properties as well. But the rate at which those properties have been removed from the state's inventory, it's been much slower than the rate that they've been added. So that number, it's probably no longer growing because so many counties have gone to the new lien bid down system. Not as many counties are doing this, the land sale system, but it's still a very sizable number. I'm not exactly sure what it is. I suspect it's over 20,000. And so that represents a loss of revenue for all the counties and the state as well, all the different government entities that receive taxes from property taxes, and it's an issue. So the state has an interest in coming up with a way to make it more efficient and encourage more of those properties to return to private ownership and begin paying taxes again. So this Act 2024-83, creates the opportunity for the state, for any properties that they've held for more than 5 years, to conduct an online auction of the properties. That would be a much more efficient system than what currently exists. Under the current system used by the state and allowed by the state for the properties owned by the state, if it's not redeemed and if an investor wants to buy the property, they have to put in an application to the state to buy it. The state sends a quote, and then the person putting in the offer has 20 days or so to respond. And a lot of times they end up not buying the property. So then the state has to go to the next person in line to buy it. It's just a very inefficient process.
Yeah.
It takes up a lot of time for people at the Department of Revenue, and it just has not been satisfactory in getting rid of those properties, get them back on the tax roll. So an online public auction should improve that tremendously. It should allow for a more expedient method of getting the properties out there for potential buyers to view and to put in an auction system, an online auction system, which has been implemented in other states, I understand. And I think will result in a lot more of those properties being sold and getting back into private hands.
Okay. Is there any timeline that you're aware of when those auctions are going to start? Is that the 2025 thing, or is it multi-years down the road? Is there any sort of indication on that?
Yeah, what I've heard is that that law goes into effect on January 1, 2025. So it will not begin until 2025. And what I've heard, but I'm it's just from sources, but is that it would probably be well into 2025, maybe into 2026 before they have the first auction.
So does the statute eliminate the first come, first serve, basis that's been existing for the state, process? Or they're going to continue to do that, and this is just going to be the, supplement that process for anything that doesn't get a bid? Or are they replacing that? Do you have any insight there?
I don't see it as eliminating the former first come, first serve process. I would think that the state would hope that this online process will result in a lot more properties being removed from their rolls. And I suspect when they get going, they'll probably put more of their time will be spent with it, and there may be less time available to deal with the first come, first serve request.
Right.
But I don't know that. That's just speculation. But it does not eliminate the first come, first serve. And the state has to hold them for 5 years. So there'll still be an opportunity, for properties that the state hadn't held for 5 years. There'll always be an opportunity for those properties for someone to go and try to buy them from the state, or for some land bank to try to pick up on them.
And you mentioned that, and I failed to recognize that the first time, but it's the key is anything new that's being assigned to the state is still going to have the first come, first serve for the first 5 years, right? Regardless. And then if it still hasn't been reassigned at that point, it can fall into this. And like you said, there's probably a backlog of tens of thousands that are already over that 5-year limit that they're looking to use this process for.
That's right.
Got it. Okay. That's I guess number one, right? Or the change number one. Is there anything more to number one, or
I think that covers. I mean, there are more details, but primarily I think the interesting thing there is that now I think it will be a better opportunity for particularly the sort of institutional investors who have a lot of resources to scan through properties, gather information, and come up with bids on a lot of properties. I think it's going to be a better opportunity for them to look into those kind of properties in Alabama than there has been in the past. I'm hopeful that will be a better system and result in more of the properties being returned to the private ownership.
Yeah, that's the hope. We reverse the trend, right? It doesn't really make sense if more and more land being owned by the state is going the wrong direction. Okay,
well, it doesn't benefit anybody. It sits there; it's not taxed,
right?
And anyway, it's usually not productive, and so anything to me to get property back into private ownership is an improvement.
Yeah, for sure. Let's dig into, I guess, change number two. What's change number two?
All right, so change number two deals with both the land sale system and the lien system, and it's a result of the United States Supreme Court's decision in Tyler v. Hennepin involving overbids or surpluses from tax sales. I think most of the people that may be watching this are probably familiar with that Supreme Court decision. It came out of Hennepin County, Minnesota, and involved the county retaining the surplus amount paid at a tax sale of some property that was owned by this elderly lady there in that county. And the Supreme Court, in a unanimous decision, concluded that while states may tax properties and seize them and sell them to recover taxes, any excess from those sales are subject to the takings clause. Those excesses, in effect, belong to the owner whose property was sold. It's their property, and the counties can't keep that money. So and if they do, then you're engaged in the taking of property. So that ruling was very clear that states can only recover the taxes, interest, and related costs, and any excess proceeds or equity in the property belongs to the taxpayer. I think that's now the details of it and what's reasonable for counties to have to do to protect people from their property being taken, those details are subject to nuance and discussion or whatever. But the concept that governments cannot seize and recover property that exceeds the amount of the obligations owed, to me, is a very standard property right that's been recognized since the Magna Carta and comes right through into American law and recognized by many statutes and also common law. So I think that's I'm very I thought the United States Supreme Court made the absolute right decision on that. How it's applied state to state is different. It's caused a lot of states to get worried about their systems, that kind of thing. But the general principle, I'm in full agreement with. Alabama had a similar legal opinion from its highest Supreme Court the year before in 2022 in a case referred to as Douglas v. Roper, which I'm very much involved in that case and in that opinion. And that Supreme Court ruled very similarly that these surplus funds represent vested rights of the persons whose property had been sold for taxes. And I was on that side of the case. I'm on the side of the case of the property owners whose taxes have been sold. The majority of my legal representation has been for tax purchasers, tax investors, but I'm often involved with helping owners whose property has been sold as well. And you know, I've never dealt with a client who buys properties for taxes who felt like the owner should not get the surplus from the tax sales. I mean, the
Right.
investor's position is I'm paying the amount I'm willing to pay for this property, and I don't get to pay that amount, get the property, and then get my payment back. You know, they all recognize that owners should get any surplus from those sales.
Right.
So anyway, this legislative change that I'm referring to right now, which is out of Act 2024-261, it was in response to that U.S. Supreme Court decision dealing with the taking of property from a tax sale. And that act addressed, like I said, it both addressed both the land sale system and the lien system. For the land sale system, how it impacted it was this: under the land sale statutes, the law had been that if there's a surplus created from the sale, the owner of the property could not recover the surplus from the county unless they redeem the property. I have felt ever since that law came into effect beginning in 2013 in Alabama that that's an unconstitutional law, that there should be no condition on the owner recovering that surplus amount.
Right.
There may be a question about who the owner is or whether a lien holder has a greater right to the surplus, but it's been my position, which I think is confirmed by the two our state Supreme Court decision and the U.S. Supreme Court decision that I mentioned, that those surplus funds do not belong to the county, and it's wrong for them to keep those surplus funds. Well, this new act, what it did was it changed that requirement and said, okay, owners can recover the surplus funds without redeeming, but if they do recover the surplus funds, they have to execute a written release and file it with the probate records, releasing any interest they have in the property and releasing any right to redeem the property. In my opinion, the state just swapped out one unlawful or unconstitutional condition with another unconstitutional condition. My view of it is that the owners whose properties have been sold, and when I say owners, in the context I'm discussing, I'm referring to any lien holders or anybody else that has an interest in that property. I'm really referring to the ownership of the real property sold versus the county. My view is that the owner has the right to the surplus. They have a right to redeem. They have whatever rights Alabama law has with respect to property sold for taxes. And they should have the option to obtain the money and redeem the property, then obtain the overplus, or just get the surplus money and not redeem it. They should have all those options available to them, and they shouldn't have to give up any rights in the property to recover the surplus that belongs to the owner. That's my view of things. I think that view is supported by the two decisions I've referred to. So I think this new statute is problematic and puts owners in a difficult situation. From the investor side, the problem with either of those conditions, the one that existed, which was the owner can't recover the surplus unless they redeem, or you have to give up your rights to redeem to recover the surplus, either one of those, the problem for investors is that many investors want to cooperate in the process of redemption, and they recognize that owners often, with these land sales, they need to recover that surplus money in order to redeem the property, because it often can be a sizable amount of the total redemption amount. So if you say to an owner, you can't recover the surplus without redeeming it first, well, then they can't come up with the money to redeem. If you say to the owner, oh, you can recover the surplus and you don't have to redeem, but you have to release your right to redeem, well, then to recover the surplus money, they have to give up their right to redeem. And so for the investor side, for investors who are always, or not always, but reasonable and want to cooperate with people trying to redeem their property, it makes it more difficult to work those situations out because the owners need the surplus money to redeem.
Right.
So that's the change that occurred as to land sales. As to the sale of lien system, the changes that occurred relate to the foreclosure of the liens. So when I was describing earlier the how the lien sale system works, you bid down the interest. If you're the winning bidder, at some point, if the owner doesn't redeem, you're going to want to foreclose your rights in the property. And the way the system, what the system allowed for, what the statutes allow for, is that after 3 years, you would bring a lien foreclosure lawsuit. You would file a lawsuit against the owner and any other interest in the property to foreclose on your lien. And if the parties with the right to redeem did not foreclose in response to that lawsuit, the result of the lawsuit would be title would be granted to the lien holder on the property, clearing up the title to the property. The concern with that system was that it would take away all the equity in the property and give it to the purchaser of the lien. I guess the concern was, well, that then results in a situation that's inconsistent with the holding of the U.S. Supreme Court decision about taking a property. Because let's say after 3 years, there's $3,000 in taxes owed on the property that have not been redeemed. The holder of that lien goes and let's say the property is worth $50,000. The holder of the property, the holder of the lien then goes and forecloses, brings their foreclosure lawsuit. There's no redemption. The holder of the lien then acquires property worth $50,000, and what someone may consider $47,000 worth of equity is then taken away from the owner without an opportunity to recover that extra value in the property. That was the concern with the previous system. I recognize there are some concerns with that. The new system, to avoid that outcome, imposes some very strict requirements for bringing that lien foreclosure lawsuit to enforce, or a purchaser of the lien to enforce their rights in the property if the owner doesn't redeem. One of the things it did, it extended the period of time for bringing that lien foreclosure lawsuit from 3 to 4 years. To me, that's a big detriment to investors, because that's a long time to continue paying taxes without the ability to force the issue. In addition, before filing the lien foreclosure lawsuit, you have to provide some very specific notice to the owner, to anybody of record may have interest, to the tax collector, that has a lot of detailed information and has a statutorily required notice that's about a half a page or page long, warning the person's receiving the notice that there's about to be a lawsuit filed, and that the result of that lawsuit could be the complete elimination of any rights in that property. And then when you bring your lawsuit, you have to file an affidavit saying you've done all that and how you did your research. And then before a final judgment's entered, the judge has to make findings that all these procedures were followed properly. Mm-hmm. So that's part of it, is to make sure everybody's notified about what's to happen. To me, that's just going to make it more difficult. To me, what that does with all those extra requirements, it just provides more opportunities for someone to later come along and challenge what was done on the basis that some technicality wasn't followed.
Right.
Anyway, and then the other major thing that this act did with respect to that concern about the surplus value of the property is it provides an option for anybody with an ownership or interest in the property at any time before the lawsuit's completed to file effectively a motion with the court, say we want the property to be sold for at a public sale, so that the holder of the lien doesn't just get the title to the property without and all that equity in the property. Now there has to be a sale that occurs, and if that motion's filed, then a process will be started to sell the property, and the result of that sale will be to first pay off the cost of the sale, then to pay off that lien holder, and then there may be some other expenses that have to be paid, and then all the surplus, if there is any, would then go to the ownership of the property. From the owner's perspective, that's a very favorable change, and it allows them, if they're going to lose their property, the opportunity to recover any surplus value that exists in the property. That's reasonable. For the investors, that then significantly reduces, in my opinion, the the opportunity to recover some value in this property more than what you put into it with a little interest. As an example, let's say you buy a property, you buy the lien year one, $1,000 lien, and you bid down the interest to zero. That's an extreme example, but that has happened. You go 4 years of paying taxes, so you've got $4,000 invested now after 4 years, and then you start your lien foreclosure process. In the end, if the people having a right to ask for an auction do so, you may only get back your $4,000 with no interest. So that's, to me, that removes a lot of the incentive for investors to bid on those properties at those lien bid down sales now, because there's less likelihood now that you're going to receive a property. You know, if you're bidding down interest on these lien bid downs, your hope is that you're going to get a property or two at the end that has much greater value than what you've invested to cover all the other properties that got redeemed. So now that the chance of that's been reduced significantly. You do, as an investor, if you have to go through that process of filing a lien foreclosure lawsuit and then living through that auction, you do get to recover reasonable attorney's fees and your expenses, but that's just like paying you back for what you spent. So in the end, in the example I gave, if you bid down, you're the winning bidder on year one down to 0%, all you're going to get back after 4 years of time is the money you've spent.
So if the goal, right, is for the property ownership, or a few of those to be property ownership, and that is potentially being eliminated, then, like you said, folks probably aren't going to bid down to zero, or there's really not knowingly shouldn't, right? So I guess it's bad for the real estate investors, but is that, there's certainly investors out there that aren't interested in the real estate, right? They just want the lien, right, the interest rate. So if it's not being bid down to zero, does that actually bode well for those folks?
Yeah, I mean, there'll still be an opportunity for investors who are looking for redemptions with the interest rate recovery, but with the bid down system, one is you have, and then this may work itself out, but my sense, and I haven't attended these sales, I don't have the data. My sense is you have a lot of people buying these properties who don't fully understand how it works,
right,
and still have in mind that they're just getting properties for very cheap, and they're going to bid it down lower than what it would make sense for a more institutional type investor to pay.
right.
People are bidding it down to 3 or 4%. I don't know. Maybe that makes sense for institutional investors, but I suspect it doesn't when the cost of money is 5% now, I think, at a minimum.
Well, and I would agree. It probably takes a few years to I'll say train everybody, right? But it also, the biggest unknown is what percentage of those properties are going to. There's some other states that have implemented what I'm calling this opt-in, right? Not every property is going to go to auction. The previous owner has to opt in through a filing for the properties to go to auction at the end of the redemption period. Correct?
What? Say that again.
So at the end of that redemption period, not every property is going to be auctioned. The previous owner has to I'm going to call it opt-in, right? They have to file for that auction to occur. So what we don't know.
The lien holder does. Just get the terminology. The lien holder. No, I'm sorry. You're right. So the lien holder initiates the foreclosure process, and yes, it's up to the owner or anybody with an interest in the property that's named in that lawsuit. It's up to them to request the auction.
So what's the unknown is what percentage of folks will actually request.
That's right.
So the difference between, like in Florida, every lien that gets sold has to go through an auction, right? That's Florida, right? And then this is kind of similar to what is now New Jersey and Arizona, where there is an auction option, but the previous interested parties have to opt in, and so nobody really knows what percentage. Is it going to be a significant percentage? Is it going to be closer to zero? Does it really change anything? That is to be determined at this point, because you don't know, right?
That's correct. That's correct. And you refer to the Florida system, and I think what makes the Florida system much more preferable to investors over what now we have in Alabama is that I think in Florida, and you can correct me, but on a lien, the winning lien bidder in Florida is guaranteed some percentage when it's redeemed, right? Isn't it like 5%?
Yeah, there's a penalty I'll call penalty, right? That's probably not the right term from a statute perspective, but there's an automatic 5%. So no matter you bid it, if you bid it down to 0, that's one thing. But you bid it down to 0.25%, you're going to at least get 5%, right?
Right.
Now that's for the first year. That doesn't get added every year. So
no, but still,
it's still something, right?
Yeah. So I like that would make Alabama's system much more attractive if there was some minimum percentage that the investors would get. But we'll see. I mean, if I've owned a few tax sale properties in Alabama through the years. I've never bought one at an auction, but I bought a portfolio from investors trying to get rid of them. And just from my experience, I can't really see the benefit of going to those lien bid down auctions. It just seems like it's more work than needed. But if the auctions resulted in interest rates of 7 or 8 or 9, 10, 12% or whatever, yeah, that might make sense for some of the bigger investors to do that. Anyway,
yeah,
I hope
in theory, most properties end up going, if the previous owners, if most of them are opting for this auction and it's being sold, right, then investors will know, hey, I can't bid to 0, right? I got to bid north, and then maybe that all occurs. But that's all a big giant question mark right now. So it's not something that you'd recommend jump in. You're going to get a better rate today than you were in 2024. That sounds like that's not the case, correct?
Yeah, we don't know. We'll have to see. I mean, but I think it may take longer than I think, and I may be wrong, but I think ultimately there'll be, from what I've heard, is a lot of the counties using these lien bid down systems are recovering taxes on almost all the properties. So it's a success from their standpoint, if that's the case. But I've also heard that a lot of investors figure out along the way, wait, this just isn't worth my time, and they just stop paying taxes, and so the property has to be sold again. I think ultimately there's a good chance that counties will begin selling fewer and fewer of these properties at the lien bid down system. And under the statute, if it does not sell at that initial auction, then the counties can conduct a private sale later for the property. And I think what's going to happen is the county is going to end up with a lot more of those properties that it has to do these private sales. I think all those properties that used to go to the state of Alabama under the sale of land system, I think it's going to be a situation under the lien bid down system where a lot of those properties that would have gone to the state are going to end up with the county trying to figure out what they're going to do with them.
Got it.
That's, that could be I don't know. We'll see. Time will tell.
Time will tell, right? We'll find out.
That's the major changes under that act. And that leads to the final one, which is Act 2024-324, and it applies just to the sale of lien system. And it addresses an issue I just kind of brought up, is that many of the investors at these lien bid down systems apparently were not continuing to pay taxes after year 1, which put things in a quandary. The question was, well, if you just buy 1 year tax, but you don't pay the 2nd year tax, could you still foreclose on the 1 year tax several years later or not?
Right.
You end up having back-to-back different lien holders and complicating things worse. So this act 2024-324, what it does primarily is it assures that subsequent taxes get paid. And the way it does that is if a winning bidder, say year one, does not pay the following year's taxes, does not opt in and pay the following year's taxes, then the property gets sold at a new sale, lien bid down sale, and the minimum bid amount will will effectively redeem the year 1 lien holder.
Oh, interesting. Okay. Yeah, so it's in most states, right? It's just another lien that's sold, right? And then there's the argument of who has priority. Some states it's the oldest, some states it's the newest. Eliminates both of those, because if there's a new one sold, it takes over both, right? So that it somewhat guarantees there's only going to be one lien holder in the life of that property. Interesting.
Yes.
I've never heard that used before. That's actually, I think I've always wondered why that wasn't used in all the other systems. So I guess Alabama.
Yeah, it makes sense to me. So if I buy year one tax $1,000 and I bid it down to zero, I have the option in Alabama to come back and pay the second year's tax, but also at 0%. And I may decide I don't want to do that. Well, if I do that, I don't pay it. I don't opt in to pay the second year taxes. Then you could come along and buy that, then that property be up for bid again the next year, and the bid amount will include obviously the amount of taxes that are due for that current year, but also include the previous year paying off my lien.
Right.
So if you were the winning bidder on year two, you're going to be paying off my lien and paying year two taxes, and that takes the year one guy out of the picture altogether.
Got it. Okay.
So that's the primary change with that final one.
Got it. Okay. So Act 1 is to review. Act 1, basically allows the state to sell properties if they've held them for more than 5 years. Act 2 really made pretty significant changes, it sounds like, both to the land sale system and the bid down system. And then Act 3 is really just solving the who has priority. If somebody doesn't want to, if a lien holder doesn't pay the sub taxes, that's basically if you come in and somebody else buys that second year, they're taking over whatever years are delinquent behind it altogether. Did I cover that? Probably
yes.
too succinctly, but
no, that's it. That's the primary changes that occurred.
Was there? I immensely appreciate the quick overview. Is there any other kind of changes that you're aware of, Will, that's in the wind out there that might?
I haven't really checked to see what's going on for this upcoming year. I'm not aware of it. These are all pretty, there's a little, well, our legislature tinkers with these tax sale statutes continuously. This is the most significant changes in a few years, but there very well could be something in the works again this year, because there's almost always some bill, but I haven't checked to see if there's any activity going on. This past year was a big one, but I'm not aware of anything for 2025.
Okay. Was there now, as far as effective, you said January 1st of 2025, is that for all three acts?
No, the only one that has that January 1, 2025 effective date is the one allowing the state to do the public auctions.
Okay.
The other two acts have already gone into effect.
Now did they go retroactive to the liens that are already out there, or are they only going to be from when they were effective to new liens sold going forward?
That's a good question.
A little fuzzy currently. They didn't define that real
well.
Yeah,
I would say that's. I mean, I think other people have asked that. So Act 2, which deals with the surplus fund situation, as it relates to the sale of land system, I don't know if it just applies going forward or applies retroactively. I don't know. I mean, it's either way, it's a problem. It's affecting somebody's property right in a negative way. The other system, the lien bid down system, the changes which were primarily dealing with the process of bringing the lien foreclosure lawsuit, which then could result in request that there be a public auction. I think that goes in effect of anybody attempting to enforce a lien whenever they bought it. So I think that will apply to liens that were purchased in the past. I think it will.
Got it.
I could be wrong. I mean, a lien holder could say, "You just changed my rights." When I bought this lien, there was no system involved for the public. That's, you raised that question, just raised an interesting issue for me. Is could somebody that holds a lien from 2 years ago who wants to foreclose say that can't be enforced against me, that request for public auction or the request for the property to be auctioned, because when I bought the property, that was not what the law was, and you changed my rights in the property by doing that. That could be an argument.
So they left it vague enough to where they'll let it be battled out in the courts, it sounds like.
Yeah.
Okay.
It would require somebody want to take on that challenge, and I don't know that anybody wanted to do that, but
sounds like a opportunity for us to circle back in 6 months or a
Yep.
year, see how that battle's going.
Yeah, I don't. Yeah, it'll be interesting to see when that gets raced for the first time, or if it gets raced at all. So
Yeah. Well, Will, immensely appreciate your time and willingness to help educate me and the audience again. Is there anything else that you think we should know before we finish up?
I think that covers it. Yeah. If anybody has any questions, feel free to send them on to me. But I think that covers it.
You got it. We'll do. And I guess everybody listening, if you are an Alabama investor and still have questions, certainly reach out to Will. His information will be in the details below. But Will, I'm sure we'll be talking again. Thank you again, and have a great holiday.
All right, you too. Have a nice weekend.
All
See you,
right.
Brian.